Good afternoon, everyone, and welcome to uh, our training on keeping families together using disability law to defend disabled parents. This is training number 1 of 2 trainings, and today we have with us 3 very experienced attorneys who will explain how disability law can be used in child welfare cases. I just want to remind you that this meeting is being recorded, so please don't share any confidential client information while we are recording on the webinar today. Our speakers are Aisha Elaine Lewis from the Disability Rights Education and Defense Fund, Robin Powell from the National Research Center for Parents with Disabilities, and Kavya Parthavan, Disability Rights Education from Fund. And we very much appreciate having all of them today. I am Linda Long-Balil. I'm at UMass Chan Medical School. And I'm going to start by just explaining a few logistics. We do have closed captioning. At the bottom, you should see a closed captioning symbol. We'd prefer if you ask your questions through the Q&A at the end. Like here's a Q&A button at the bottom. That would be very helpful. And I also want to mention that we do have sign language interpretation, and there should be a little button at the bottom of your screen if that is something that you would like to use. And thank you to our interpreters. We're going to start today with definitions of disability. Then we'll move on to the basics of Title II. That's the title of the ADA that applies to the state and local government, and its application to child welfare cases. We're then going to talk about relevant case law and trends in the states, and we're going to give a few case examples. And then we'll do questions and answers, and we'll do a little wrap-up. So thank you, everyone, for attending. So I'm going to turn this over now. I believe that Attorney Lewis is a bit delayed, so her colleague, Kavya Parthavan, is going to take on this part of the webinar. Take it away, Attorney Parthavan.
Thanks, Linda. This is Kavya speaking. So first, we're going to define what a person with a disability means under the Americans with Disabilities Act in Section 504. Disability is a very complex and fluid term. The medical system has different definitions. There's a social model of disability. But for the purposes of getting protection under ADA and 504, there's 3 ways to meet the definition of disability. The first is that you have a physical or mental impairment that substantially limits one or more major life activities, or you have a record of such impairment, or you're regarded as having such an impairment. Now, the term impairment's quite broad, but the limiting factor is that it substantially limits one or more major life activities. Next slide, please. So when we talk about clients with disabilities, who do we mean? Oftentimes when we train folks, people think of folks with disabilities as people in wheelchairs or folks who might have a vision impairment or who are deaf. But that's not the only group of people who are covered under the ADA and Section 504. Next slide, please. So clients with disabilities include people with psychiatric disabilities, post-traumatic stress disorder, which I'm sure many of your clients are showing symptoms of when being involved in the dependency system, counts, things like bipolar disorder and schizophrenia, depression, anxiety, obsessive compulsive disorder. Traumatic brain injury is also disability that we're learning more about that counts. You have autism, intellectual disabilities, mobile disabilities, sensory disabilities, learning disabilities like dyslexia, ADHD, and chronic illnesses also count. So, if a person has asthma or high blood pressure or history of cancer, those are disabilities that can count as well. Next slide, please. So what the key point on who is protected by the ADA is that it needs to substantially limit a person's major life activities. When we're looking at various disabilities, when folks hear things like intellectual developmental disabilities. What we're talking about is a disability that it has significant limitations in intellectual functioning. And so that might affect how a person does, problem solving or socializing. Um, and it usually originates before the age of 21. When we assess intellectual disabilities, oftentimes what's being used is IQ tests, which have been, there's been a lot of critique around IQ, and IQ does not relate to parenting capacity. But, IQ tests are one of the ways that people are diagnosed. When we look at parents who have an intellectual disability, oftentimes folks who have an intellectual disability have a mild or moderate intellectual disability, so it might not be catched as much. We've talked about, the psychiatric and mental health disabilities that count. I'm going to quickly also talk about substance use disorder because substance use disorder can be a disability, but it's not always covered by the ADA. If a person is actively using an illegal drug, then protection is not there. But if they've completed a rehabilitation program and stayed sober, and then you're using the fact that that person had a history of substance use disorder against them, that it could be protected. So Title II prohibits discrimination when people have substance use disorder solely based on the fact that they previously used. We also want to acknowledge that relapse is a part of recovery. So even though we might understand substance use disorder as sometimes having relapse in it, ADA doesn't cover it once that relapse happens. Next slide, please. So how many of your parents have disabilities? If we look nationally, we have reports that 1 in 10 children have a parent with a disability. And we've seen that children with parents with disabilities can thrive, especially when those parents are accommodated or are able to use their support systems. Oftentimes, children do well with parents with disabilities because they learn about disability culture and how to accommodate their own disabilities. And we also have high quality studies that show that when you control for disability alone, that's not predictive for abuse or neglect. What is true, though, is oftentimes people with disabilities are also low income, have limited resources. And so because of poverty, you might see higher reporting of neglect. Next slide, please. So even though, children of parents with disabilities comprise around 10% of the population, and that's more than most people think, they make up close to 20% of the youth in foster care. Now, the reason for that is, again, neglect, maybe misunderstanding of disabilities, but we see removal rates and worse outcomes for particular parents with disabilities. For folks with intellectual cognitive disabilities or psychiatric disabilities that are stigmatized, like schizophrenia or bipolar disorder, those removal rates are up to 80%. Removal meaning child welfare thinks there's a risk and they remove. And then once their child is removed and they're subjected to dependency proceedings, their cases are more likely to be substantiated for neglect compared to similarly situated non-disabled parents. They're less likely to receive proper family preservation services or reunification services at all compared to the non-disabled population. And just because sometimes people think, well, if you remove the kid from a parent with a disability who's in maybe a low income environment, maybe their outcomes are better. But the research also shows that children with parents with disabilities often have longer foster care stays and 32% lower odds of being reunified. We know that being reunified with your family results in better outcomes for youth as they enter adulthood, and children who stay in foster care for a long time also are more likely to have their kids removed when they become adults too. So the results are not that great. Next slide.
Oh, that's when
and I'm going to Robin.
Yeah.
Yes.
All right. So now I'm going to talk about the intersection of disability law and the child welfare system. And to give you sort of a broad overview, we know that the ADA, specifically Title II of the Americans with Disabilities Act, applies to all state and local government entities and their departments and agencies. So this would include, of course, the child welfare system. It also includes courts, so I think it's worth recognizing that. And also lawyers have to comply with the ADA under both Title II and Title III, depending on what type of an attorney you are. It's also worth noting at the outset that Section 504 of the Rehabilitation Act also applies to the child welfare system. While I'm going to focus primarily today on the ADA, Section 504 has many of the same obligations. Section 504 applies to anything that receives federal funding. And I'm raising this specifically because in last spring, the Department of Health and Human Services issued new regulations on Section 504. And there's an entire section now related to the child welfare system, specifically related to parents and children with disabilities. So it's worth sort of understanding that the ADA is an important tool, but Section 504 is also equally important and often overlooked. Next slide, please. Next slide, please. So let's go over what sort of the ADA requires of the child welfare system. Well, first we know that under the ADA, child welfare agencies do need to provide an equal opportunity to parents so that they can participate in all programs, services, and activities that are provided by the agency. And this includes providing reasonable modifications as necessary so that a parent can participate in whatever that program, service, or benefit is. Again, a reasonable modification would be required, something to adapt it so that it becomes accessible for a disabled parent. And that's unless that modification would fundamentally alter the nature of the service, program, or activity. And we will get into that in a few minutes. So I'm going to put a pin in that for now. We also know that the agencies must administer their services, programs, and activities in the most integrated setting appropriate to the needs of that parent. So again, parents with disabilities should be integrated into the average services that are available through the system. In addition, the agency cannot impose or apply any type of eligibility criteria that might screen out or tend to screen out a parent with a disability from being able to participate. An example of this might be a parent education class that requires that a parent be able to go up a flight of stairs or be able to read at a high level. All of those things would tend to screen out certain parents with a disability. So that would be unlawful under the ATA. Next slide. In addition, child welfare agencies must provide parents with auxiliary aids and services when needed to ensure effective communication. Examples of that would be sign language interpreters, captioning, large print, digital formats of documents, anything that ensures that the communication is then accessible to the parent. In addition, it's important to understand that the ADA does require that agencies go beyond sort of those that are generally required when needed to ensure that a parent can access a service or benefit, whatever it may be. In addition, agencies cannot charge parents to cover the cost of any of these measures that are taken to provide that non-discriminatory treatment. So again, if they provide an interpreter, for example, they can't then go and say, we'll provide the interpreter, but the parent will have to cover it. That is not allowed under the ADA. Also, agencies may not deny any programs, activities, or services to parents simply because their facilities aren't accessible. What that means is that they would need to relocate anything that is inaccessible to an accessible location. And when we look at sort of everything they provide as a whole, we know that all services, programs, and activities must be viewed as readily accessible to and usable by parents with disabilities. Again, making sure that they're fully accessible to parents with disabilities. Next slide, please. So there are two key fundamental pieces of Title II of the ADA that I want to focus in on a little because I think they're particularly relevant to parents with disabilities. The first is individualized treatment, and the second is full and equal opportunity. And I'm going to go through each in depth a little more. Next slide, please. So individualized treatment is really sort of at the key of the ADA, I think. And what the individualized treatment mandate of the ADA says is essentially that parents with disabilities must be treated on a case-by-case basis that is consistent with really facts and objective evidence. What that means is that agencies cannot act based on sort of biases or speculation. They can't say, we know that all parents with X disability are unable to safely care for their kids, it requires that the agencies really look specifically at that parent's circumstances, look at sort of what that family dynamic looks like, really look at sort of how that person experiences their disability, what their support systems are like. And so it is really supposed to be on a case-by-case basis, and that disabled parents cannot be treated based on sort of those generalizations or stereotypes. Some examples of this would be things like removing a child from a parent with a disability based on some stereotypical belief that is not supported by any type of assessment that parents with disabilities cannot safely care for their children. Another example of individualized treatment is really, something that's not allowed would be denying a person with a disability the opportunity to adopt or become a foster parent based on, again, some belief that that person's disability could affect that person's ability to care for a child without any sort of evidence to back it up. Next slide, please. In addition, as I said, the other key principle is full and equal opportunity. So parents with disabilities must be provided opportunities that allow them to be able to benefit from or be able to participate in all programs, services, and activities that are provided by the child welfare agencies so that they are equal to those that are provided to non-disabled parents. So again, they have to be provided that equal opportunity, that full opportunity. And this can require that the agency provide any type of aids, benefits, or services that might be different from those that are provided to other parents when it's needed so that that equal opportunity can be achieved, so that parents with disabilities can have that same result or be able to gain that same benefit as non-disabled parents, things like family reunification. Next slide. So when we put those two key principles together, again, individualized treatment and full and equal opportunity, we need to understand that that does not mean that agencies need to lower standards for parents with disabilities. Instead, it means that these services, these services must be adapted to be able to meet the needs of the parents so that they can provide meaningful and equal access to that benefit being offered by the system. In addition, we know that that might mean ensuring sort of that physical or programmatic accessibility or providing that auxiliary aid or service to ensure that there is that effective communication and that ability to participate. For example, an agency must provide an interpreter to a parent who is deaf when needed to ensure that they can participate in all aspects of their interactions with the child welfare agency. It can also mean making those reasonable modifications to policies, procedures, or practices. An example would be that if a child welfare agency were providing classes related to maybe feeding or bathing children, and there's a mother with an intellectual disability who needs some different form of instruction to be able to learn those techniques, the agency will need to provide the mother with that method of teaching that she needs. Again, the goal is always going to be to ensure that parents with disabilities have individualized treatment and full and equal opportunity. In addition, as I mentioned earlier, there are a number of defenses or exceptions that need to be considered. The first is fundamental alteration. That means that an agency can say, I can't provide that modification that the parent is asking for because it would fundamentally alter, it would fundamentally change the nature of the service we're being offered. That is a really high bar. And in fact, all three of these are really high bars. So it's important to understand that. But a fundamental alteration really is just saying like, this would completely change what we're doing. You're asking to learn how to do X, but this class is on another totally different topic. Again, the excuse would be, we can't do that because it would change what we're doing. Another sort of defense would be it causes an undue financial or administrative burden. Again, we can't afford this. This is something that agencies do often assert. Again, the burden would be on them to prove it. And then the third and final defense is direct threat or legitimate safety requirements. And in those instances, what the agency is saying is that there is a direct threat to others. We cannot reunify the child, for example, because the parent poses a direct threat to the child. Again, another high bar that the state would need to prove. All right, now I'm going to get into some state trends and case examples. Next slide, please. So the Department of Justice has been very engaged in these activities, along with the Department of Health and Human Services. They first started their engagement in January of 2015 with what is called the Sarah Gordon Letter of Findings. This involved a mother with an intellectual disability in Massachusetts who had had her child removed shortly after birth. The DOJ and HHS came in and said that the state had violated the ADA as well as Section 504 of the Rehabilitation Act by not treating that parent on an individualized basis, not providing that individualized assessment, and really acting based on sort of broad generalizations and stereotypes. About 7 months later, in August of 2015, the DOJ and HHS issued technical guidance together, which is really good. And I've seen courts cite to it several times since its release. It really does detail exactly what agencies' obligations are. So for those of you on this webinar, I would strongly encourage you to look at this guidance. It is available on the ada.gov website. Then in December of 2019, we saw that the Department of Health and Human Services entered into a voluntary resolution agreement with the state of Oregon after there were complaints by individuals that the agencies were violating the rights of parents with disabilities. In November of 2020, we saw DOJ and HHS enter into a settlement agreement with the state of Massachusetts, where they really sort of pushed on what they had originally found in the Sarah Gordon letter of findings and said, really, this is a systemic problem. This wasn't just an issue that happened to this one mother. In 2021, we saw DOJ enter into a settlement agreement with the state of Washington. This was with respect to providing accessible communications, primarily to parents with disabilities, again, not providing them, which violated disability rights laws. In March of 2022, we saw DOJ and HHS get into another voluntary resolution agreement where they found the state of Rhode Island violated the ADA and Rehab Act. In August of 2023, we saw that there was a voluntary resolution agreement with the state of Pennsylvania. And this one was interesting because it related to parents who had substance use disorders. And that's something that Kavya mentioned, sort of that is not often talked about, but it is relevant. And then most recently, and it's not even on this timeline because it's so most recent, but there was a activity with the state of Arizona. Again, another resolution agreement because the state of Arizona was found to be violating these disability rights laws. And I bring all of this up because I think it demonstrates that lawyers can look to HHS and DOJ as hopeful partners in promoting the rights of parents with disabilities. Next slide. So as I mentioned, the letter of findings related to the Sarah Gordon case was really sort of the beginning of all of this. And I went through the facts already, but I think what is important to understand is that they said the state needed to provide appropriate supports to parents with disabilities, and then also the opportunity to be able to demonstrate fitness, because in this situation, the child was removed shortly after birth, and the mother hadn't even been given a chance to show that she could care for her child. Luckily, this case did end happily. After DOJ got involved, the family was ultimately reunited, but it took over 2 years to get there. Next slide. This is the technical assistance I mentioned earlier, a really important document for all lawyers that are involved in this area to have on hand. Next slide. There's a few other cases that I just want to make sure attorneys are aware of. There's a really good decision that came out of the state of Michigan in 2017. It involved a mother who had an intellectual disability. She had never been provided reasonable accommodations. The agency just took the children away. And the agency was essentially saying that they didn't know that the mother had a disability. She never requested accommodations, but they did. It was clear that they did know that the mother had a disability. And what the court ultimately did was they reversed the termination of parental rights. And they said that the courts and the agency had a responsibility to ensure that the parents' disabilities were reasonably accommodated if they knew or should have known of the parents' disabilities. So that was really important because it placed the responsibilities on the agencies, on the courts, to ensure that parents who have disabilities are being properly evaluated and accommodated. And before this case, the parent had to raise the ADA or its protections were considered to be waived. So this was a really important case. While it is only in Michigan, I think it's important and other states have cited to it since then. Next. Another case worth knowing comes out of Colorado. This case involved a mother who had a psychiatric disability, who was considered to be essentially what they called unwilling to comply with mental health treatment. The father also had a psychiatric disability. The parents had had the older children, their parental rights terminated. And in this case, the trial court it wasn't a great outcome, but it had good language. So that they found what they said was that there was no appropriate treatment plan that could be devised to address parents' quote unquote unfitness due to their disabilities. At that point, the parents did appeal the TPR. The TPR wasn't successful, but it did find that the ADA did apply to all of this, which was the first time a Colorado court had recognized this, which is why I bring this case up, because they did say the ADA applied to the providing of assessments, treatment, and any other services that a department provides to parents with disabilities through a dependency and neglect proceeding. Again, this is critical because it was the first time that the courts had recognized in the state of Colorado that the ADA even applied. Next slide. Another case out of Colorado that's a little more recent involved a mother who had both intellectual and psychiatric disabilities, and she had an infant child. The court had found that the parents' disabilities were sort of pretty significant and they were severely limiting the ability for that parent to care for their child. Of course, the parents did appeal, and what they were saying is that the department had not made reasonable efforts to reunify them with the child or to be able to even rehabilitate them in light of both Section 504 and the ADA. Again, this was an unsuccessful appeal, but again, it does raise some important law around sort of all of this. It says that the court must consider if reasonable efforts were made to be able to rehabilitate a parent. And that standard will be met when services are provided, things like assessments, case plans, referrals to assistance, etc. And again, it also says that the court must account for and make reasonable accommodations for the parent's disability whenever making a treatment plan. So again, while this was not a great outcome, it was important because it recognized that the reasonable efforts did need to include sort of the consideration of accommodations for disability. And really what they were saying is you cannot provide reasonable efforts if it's not accessible. So again, bad outcome, but really important case law. And now I'm turning it over to Kavya.
Hi, this is Kavya. So I'm going to talk a little bit about California. DREDF does operate nationally. Our focus is California right now. And California, like most other states, dismisses the ADA or doesn't really acknowledge it. And I think it can be helpful for us to look at the trends in California because it's probably trends and arguments that you're seeing in your own states. And I'm going to kind of talk through each of the two cases in California that says the ADA doesn't apply and why it's wrong, because you're probably going to have to make similar arguments when you're saying cases like these are wrong, and also highlight some of the trends that you might be seeing in your cases as well. So in California, there's only two published cases that contend with the ADA, and they say that the ADA don't apply. They were decided in 2000, which is 8 years before the amendments and now 25 years after we've had all this information. They're still in the books and courts still look to them. Those cases are Inree Diamond H and Inree Anthony P. So I'm going to start with Inree Diamond H. In Inree Diamond H, you had a mother who had a developmental disability, and she's had a large child welfare history. So she's already had children removed from the state. Her reunification services have been terminated. When they get a petition, when they get an allegation for her youngest child, the state removes the child and they move to bypass her for reunification services. Now, California, like many other states, have statutes that say you can use parental disability alone for removal. You can use it to say that a person didn't advance on their reunification services, and you can use it to bypass. But that's not the statute that they used in Inree Diamond to bypass mom. Instead, they used a statute, 361.5B10, which says she failed to reunify with her other children, so she shouldn't be able to be given a chance now. I'm highlighting this because I think this is what we often see for parents with disabilities, at least through California, where a parent might not have had a proper diagnosis in the past. We know marginalized communities are often misdiagnosed or underdiagnosed, and they may have not gotten the proper services in the past that have led them to not be able to reunify with their kids. And then when they have a new kid, those cases follow them, and then it's used to deny them the opportunity to reunify again. So, there's no questioning in this court case of in those past cases where the service is actually accommodative of her disability. There's no questioning of, is there something different now that can help her to reunite with this kid now? So I just want to highlight that piece. Now, the court says the ADA doesn't apply, and what they say is that the ADA doesn't allow for a parent to attack a state court order during a dependency proceeding. And they do so by saying three things. The first thing they say is Congress did not intend to change the obligations imposed by quote unquote unrelated statutes. So if you look at what they're citing to, at that time, they're citing to other state court cases that say the same language. And those cases cite to the ADA's purpose clause. The reason I mention that is because if you look at the ADA's purpose clause, what it says is that Title II is meant to invoke the sweep of congressional authority to eliminate discrimination against people with disabilities. It's quite illogical to think that means that it wasn't meant to apply to unrelated statutes. And also, right before this case, you have the Supreme Court case, Yeski, that comes out that interprets Title II and says, where Title II's ambiguity is there, you should assume breadth. It's meant to touch everything. So instead of looking at that, instead of actually looking at the purpose clause, they look to these other court cases in other states that say ADA doesn't apply and use that. The second thing that they say is that just because a parent can't bring up the ADA in dependency court doesn't mean that they can't bring up the ADA. They can bring it up in a separate cause of action. But then doing that means that Title II doesn't have teeth. That means that a parent has to wait until their rights are probably terminated before they can go into a civil action and say, I think I was discriminated by the ADA. And even if they win on that part, you can't undo TPR. So it doesn't really support a parent in that way. The third thing that they say is, and what I've seen a lot of other state courts say is, we don't need to look at the ADA because our dependency case law right now already tells you to consider a parent's disability. And, the ADA, like a lot of federal anti-discrimination laws, it sets the floor for what is required, and states can always offer more, right? But when you look at how the case law, at least in California and some of these other states, consider parental disability, they don't do what Robin was saying the ADA does. They don't do the individualized assessment. They don't try to provide equal opportunity. They don't consider and contend with reasonable accommodations. What they say is, I looked at the disability, I made a referral to the state agency, and so I met my burden. So that's not what the ADA is requiring. The ADA requires more. Henry Anthony is the next case. Also in 2000, it involves a mom who is a psychiatric patient. She's hospitalized, and she also has some self-harming behavior. Her sister files a petition saying that she wants custody of the 9-year-old. And CPS, agrees with the sister. They say we should terminate her rights. Custody should go to sister. Mom raises the ADA and says, I think this petition is preempted by the ADA. And she also, if you look at the court opinion, mentions that the agency made this decision without even interviewing her. So it's based on speculation of what her diagnosis is. It's based on what other people are saying. They never even gave her a chance to really talk about what was happening for her. The Court of Appeal, unfortunately, agrees with CPS and the sister. And what they say is that when the ADA is talking about covering services, programs, and activities of a public entity, termination proceedings are not within that. The reason they say that is they say, dependency proceedings are for the benefit of the child, not the parent. So the services, programs, and activities, the TPR termination proceedings don't count for that for parents. Now, the reason that's incorrect is because what our Supreme Court said is that even when, people are involuntarily brought into proceedings that incarceration or parole proceedings, the ADA still applies. You still have that obligation to ensure that they're given equal opportunity, to ensure individualized treatment. And the guidance and all these other state case law that comes after it also affirms that services, programs, and activities counts and subsumes everything child welfare agencies do and dependency courts do as well. Next slide, please. So you have these bad case law in the books. Many states do. What do you do with that? Well, you raise why your particular state's case is wrong. You can go through the same kind of logic I did with the court, say, Henry Diamond's wrong because of XYZ. Look to the guidance, look to what the DOJ is saying, how the ADA does apply. We have so much more information now. And What's also effective is to couple it with whatever dependency case law you have in your own state. So even though, I mentioned California doesn't have as strong as protections for people with disabilities in dependency proceedings, there is some language that mimics what the ADA and 504 is saying. And so what you can do and what we've advised people to do is to say, this is why it's wrong. This is what the ADA says. And this is what our case law says that suggests that we should look at the ADA. And even if you don't want to make a ruling on whether the ADA applies, you can at least look at that guidance to help you assess whether something is a reasonable accommodation, to help you assess whether you're following our dependency case law. So, for example, in California, we have case law that says it's not sufficient to merely show that a parent suffers from a mental health disability. The agency must show that how the child has been harmed by the result of disability. That goes to individualized treatment, that goes to no speculation. California also says harm to the child cannot be presumed from the mere fact that a parent has a mental illness. Very similar to ADA logic, ADA language, say no speculation, say no generalization. Next slide, please. We also have case law that says, disability should be the starting point for family reunification services, and a failure to tailor instead of accommodate, and failure to tailor and accommodate the needs of disabled parents can violate reasonable efforts. That's a bit closer to the Henry Hicks Brown language that we want. And what, other case law that's come out of California since we've made this slideshow deck shows is that you have to look at all of the facts. Like, is there support people around that can help the parent? Is the parent attempting to engage in services to support their disability? You can't try to make the disability go away. You need to make sure that the parent's given enough support to mitigate that risk. That's what the focus is. Next slide, please. And now I'm going to briefly talk about, why having the ADA apply would be helpful. And these are based on some case examples in California. So the first one is a mother who she has schizophrenia and she has a teen daughter with her at the time. She is unstably housed. They're living in a hotel temporarily. And because of a lapse in her being able to get her medication, she eventually experiences a psychotic episode. And the kid is the one who calls the cops saying her mom needs help. Now, during that episode, mom is vocalizing some suicidal ideation. And, we understand that it's because there's a lot of moving that's been happening with the family and she doesn't have access to her medication. When you looked at what the CPS report was saying, there was a lot of assumptions about mom's schizophrenia and how that was going to cause a risk to this child who also had a disability. She had an intellectual disability. And so it supported this idea that we should remove this child and place her in foster care. And for many states like California, when you're a teen, there's not really a foster home. You're placed in group home placements. Next slide, please. So when you look at the allegations aren't actually capturing the full story. Once we interview the parent more, once we learn more about this family, what we learn is that mom has been on top of ensuring that her daughter gets all the specialized school services. She enrolled her in a specialized school for her disability. The child and the mom both say that they have a very positive and loving relationship. The kid says, I've never seen my mom experience this. This is the first time. I think it's because, we've had to be unstably housed, and that's probably why she lost access to her medication. And the reason that they were unstably housed is because the kid had told the mom that someone in the home was potentially violating her. And so mom made the decision, yes, we need to move, we need to leave because you guys are not protecting my kid. And then also when you're looking at how the kid is in the group home, when the kid had high needs, the group home facilities would always call the mom. Like, they didn't know how to manage the kid's, symptoms. The mom had to be the one counseling them. So all of this kind of supports that this family is more supportive. I think in retrospect, what happened was this kid was close to 17. And the idea that was going on in CPS's mind and maybe minors council is that this kid could benefit from getting extended foster care benefits, and it would probably be better than letting her live with her mom who's unstably housed and has this disorder. But in reality, what happened was this kid was placed in this group home far away from mom, needs weren't being met, and she was eventually recruited into sexual exploitation, and mom had to be the one who had to pull her out of that. So the involvement in foster care was actually much worse, even if it could have given her access to housing in the future. Next slide. Now, there's, a lot of myths about certain mental health disabilities like schizophrenia. Sometimes we think people with schizophrenia, if they have a manic episode, they're going to do something that's going to harm people. When in reality, most people with schizophrenia are not violent. They're more likely to have self-harm ideation when they're experiencing an episode, and they're more likely to actually be victims of violence. And if you don't understand some of those serious mental health conditions, people think that there's like an on and off switch, that like one day you're fine and then all of a sudden you're having an episode. When in reality, there's like a lot of signs that there might be psychosis impending, and there's ways to manage it and get people support ahead of time so that they have a safety plan so they can safely parent their kid. Next slide. The other piece, and Robin talked about this, is with the fundamental alteration and cost piece, is one of the reasons that I think states and child welfare agencies are so nervous around acknowledging the ADA is because they think if they have to provide reasonable accommodations, it's going to cost them a lot of money, or it's going to be impossible, or that the case is going to take way too long, and then this kid's going to be waiting in foster care. When in reality, some accommodations do cost some money, and sometimes the state should pay for it. But some of them can be more affordable. And many of you might have been actually accommodating your clients anyway and not been calling it an accommodation. Accommodation is a fancy word for saying, how do we give you what you need so you can participate, right? So this was a case where there was a mom who had an intellectual disability. Her attorney was having some challenges communicating with her about what was happening in the dependency process, and was considering, should I appoint a guardian ad litem because maybe she doesn't understand what's happening, and we're worried that she might, make decisions that are going to harm herself more in the process. The reality was that her case was happening during Zoom time when COVID was high, and she was getting confused about who her attorney was, who the CPS attorney was, who the minor attorney was. And so the accommodation that we did is we went and spoke with her in person. We repeated the information multiple times in different ways in plain language. And eventually we drew her a visual aid. It didn't look like this, but we drew her a visual aid of like, this is what you're seeing in the courtroom. This is the order of how things talk. This person's not your attorney. That's the CPS attorney. This is your attorney. And your attorney might be able to say something back to the CPS attorney, but sometimes they can't because it's in your best interest to stay quiet sometimes. And once she was able to get that information, she was able to communicate to her attorney what she understood, and they were able to avoid a GAL being appointed in that moment. And you all probably know this better than I do. Once you have a GAL, even if the GAL's, representing a guardian ad litem is representing your parent's interest as best as you can, visually, if you see someone else standing in the shoes of the parent at the courtroom, the judge is probably going to think the parent can't do it. So we want to avoid having people step in for the parent as much as possible, and you could do that through accommodations. Next slide. And now I will let it be Q&A.
Okay, so for the Q&A, I'm going to turn this over to Attorney Lewis, who will lead the question and answer, and then I'll follow up with a few ending remarks. Attorney Lewis?
Thank you. The first question that we have is whether the PowerPoint will be available for future use. And that was also asked for other folks about having the slides shared after the webinar. The answer to that is yes. We will be sharing them so that you can use them as a reference for future use. The next question is, I discovered recently that YIC of a parent with mental/intellectual disability is a recognized ground under the Title IV regulations for state to get funding for another planned permanent living arrangement, i.e. long-term foster care or something similar. Do any states make use of this? Robin, could you answer?
No, I have not heard of that. I think YIC is youth and care. And so I have not heard of that. I don't know if Kavya has, but I have not heard of that, so I can't say for sure.
This is Kavya. I don't know what YIC stands for, so maybe knowing what the acronym stands for might be helpful.
I think it's youth and care.
Youth and care.
I think so.
Yeah, I'm not familiar with this either.
Okay. If you're able to send an email to us after, to, make sure that youth in care is the acronym that you meant, please feel free to follow up. Thank you. Another question that we have is whether the interactive process around accommodations applies to reasonable modifications in child welfare services.
I can take a stab at this. So the interactive process that comes from Title I of the ADA, which is all about employment. So while the concept isn't explicitly in Title II, the idea is still the same. Instead of that idea of interactive process, it's really just changed to individualized assessment when it comes to Title II. So it is essentially the same procedure. You make the request, and then you are supposed to have a response. You're supposed to engage. And so while again, the term interactive process comes from Title I of the ADA around employment, the concept is still the same.
The next question is, have any parents in any jurisdiction succeeded at raising the lack of accommodations and services as a defense in termination of parental rights? There is an Illinois case in re-SR, and I've put the citation in the chat, rejecting that approach, insisting on an objective standard in progress in rehabilitation, trying to catch more of these issues proactively, but as a public defender, frequently taking over other people's pending cases, it is not always possible to do proper advocacy on the front end.
So that
Robin,
is
Kavya.
That's a challenge. I can start, and Kavya, you can jump in if you have more. But I think that's one of the issues is that most jurisdictions continue to say essentially that the ADA is not a defense to TPR. But I think that part of what is a defense to TPR is that the parent wasn't offered reasonable efforts, right? And so you can make the argument that they weren't offered reasonable efforts if it was not accessible, and that is what is in the Hicks case and other cases, essentially, that say they dovetail with one another. And so while there hasn't been a ton of movement, essentially explicitly saying rather that the ADA is a defense, the ADA applies up to everything else. And so I think the argument then becomes that the parent wasn't ever offered the opportunity to attempt sort of what they're asking of them. Kavya, do you have more to add to that?
Yeah, the only thing I'll add is, and I feel like it's probably similar in other states too. In California, by the time we get to the TPR stage, there's multiple stages where we're analyzing whether reasonable efforts and services were given at the 6-month, 12-month, 18-month. Then there's a little bit of a lag, like a couple months before the TPR. And so I say that to say, once you're at the TPR, what we often see is that the shift after they terminate reunification services is on the child's permanent plan. And so it's hard for a parent really to ask for more in that in between. Maybe they can file something for a modification saying there's a lot of circumstances that changed, but they are the ones who have to show changed circumstances. It's not on the agency anymore. But you should be raising the ADA at all those other like status review hearings. So even if it's not the 6-month, even if it's not the 12-month, even if you're at the 18-month and you're like, dang, I didn't raise reasonable accommodations in the other one, still raise it there. Say, we know more information now. The parent has been asking for these accommodations. We have more clarity on what the disability is. And so we're saying that this 6 months that was there didn't have reasonable efforts because the agency also knew about those things. So by the time you get to TPR, it's really hard because the focus of the whole proceedings just shift. So even if you can get it before the last status review hearing, before you can get into TPR, would recommend that because that's a little bit easier.
I also think it's just worth mentioning, raise it early, but for sure, but make sure if you didn't raise it early to at least please put it on the record at the TPR hearing, because it cannot be appealed generally if it's not on the record at all. So you do want to create that record.
How do ADA laws affect AFSA deadlines for TPR, etc.?
Kavya, do you want to jump in or do you want me to?
Sure. I think it's very similar to the answer that Robin and I kind of gave before. What you can say is it's when a parent's raising the ADA, they're not saying ADA, so you can't, terminate my rights even though I didn't reunify successfully. What we're saying with the ADA is reasonable efforts, which is the language in ASFA, weren't met because you didn't reasonably tailor or you didn't reasonably accommodate. So if you are able to show reasonable efforts weren't made because you say something like Henry Hicks Brown, that ADA dovetails and they didn't do that, you should be able to extend the timeline. You should be able to get an extra 6 months. Different states have different like strictness on the timeline piece, but you use the ADA to help interpret the reasonable efforts standard.
And the Adoption and Safe Families Act, the ASFA, does say, you know, that while the timelines exist, if the parent hasn't been provided reasonable efforts, they are more flexible, I think. So there is arguments to be made.
This is Aisha again. Some of the questions are a little similar. So,
I think we have time for one more.
okay,
Probably need to move on.
I'm going to combine to one question. And this is also going to be touched upon in our next training. So even though we can't expand on it fully, sit tight. But the questions are about how do you figure out what accommodations are best for a client with an intellectual disability or a psychiatric disability?
Well, we are going to touch on this next week at the training, but I will say a few things. First of all, ask the client. I know that seems simple, but people often forget to ask the parent what would work for them. And it's things like what helped you learn in school? What do you do to sort of what do you do to function in the world? Sort of how are you accommodating yourself? And sort of, I think getting at those questions can be helpful. There isn't a checklist as much as everyone would like that would just have a blanket list of all the accommodations because it is so individualized. But there are, and we'll talk about next week, strategies you can consider. It is going to be on the parent and their attorney to essentially know what to ask for, but that's where you get into the importance of an adaptive parenting assessment and things like that, which we can talk about next week.
Great, thank you.
Okay, thank you.
All right. Actually, let me just add, there's an organization called the Job Accommodation Network, www.jan.org. And even though their accommodations are intended for employment, I think they can be useful in any setting. So it doesn't hurt to look at their website. So a lot of very useful information there. So moving on now. Thank you, Attorney Lewis. I just want to note we do have a second training next week. The focus of that is going to be legal strategy, advocacy strategies for defending the rights of disabled parents. And it will take place at the same time, same station, Wednesday, May 14th, from 2 to 3 p.m. Eastern, 1 Central, 12 Mountain, and 11 Pacific. And after that second training, those of you who signed up for the survey, thank you very much, will receive a second survey, a post survey, to help us understand what you learned and how it may have changed how you think about things. So here are some helpful resources for you. The National Research Center for Parents with Disabilities, the Disabled Parenting Project, Rocking the Cradle, which was for which the lead author was our very own attorney Robin Powell, and it focuses on ensuring the rights of parents with disabilities and their families. The Child Welfare Information Gateway, and the Association of Successful Parenting, which does trainings for all kinds of audiences who work with people mostly with intellectual disabilities. And lastly, the Bazelon Center for Mental Health Law. We are on X, formerly known as Twitter, Facebook, and you can always reach us at lori.brandeis.edu on the internet. And I want to thank the National Research Center for Parents with Disabilities and the Disability Rights Education and Defense Fund for presenting this webinar today. This was funded by the National Institute on Disability Independent Living and Rehabilitation Research, and we're very grateful for their support. So thank you very much. We look forward to seeing you next week, May 14th, 2 Eastern Time, 1 Central, 12 Mountain, and 11 Pacific. Thank you very much and have a great week.